Hello, this is Robert Perkins, the Immigration Professor, and today we're doing video part 4 of our series on de-stressing deportation. And the subject of this video is cancellation of removal or cancellation of deportation, but this time, unlike video number 2, we're going to talk about cancellation of removal for people that are in removal or deportation proceedings that already have a green card. And what happens is the government is seeking to take away their green card and remove them or deport them from the United States because they have committed a crime. You can see all of our informational videos on our website, www.immigration-professor.com. If you have a specific question about your case or need representation, please call our offices at 310-384-0200. We do immigration law all around the world and all across the United States. We also have regional offices in California and in Illinois. So what happens when someone has a green card, they've committed a crime, the government is trying to deport or remove them? Before we get into that in a little bit more detail, I want to say in a lot of the cases that we see, the person for whom the government is going after could have applied for citizenship. We're here for at least 5 years and could have applied for naturalization. So one thing, and we'll go over this in another video on what to do when you become a permanent resident, is if you naturalize, you are not subject to removal even if you commit a crime or even if you live outside the United States. So I think one important thing is not to get in this situation is that when you get a green card to subsequently, or a few years later when you're eligible, to become a naturalized citizen. But let's say you didn't. Here's what happens. So for cancellation of removal, in order to be eligible to try to stay, and I'm going to underline the word try because it is discretionary, it's up to the judge, you actually have to have been in the United States for 7 years. You have to show you've been here 7 years after entering legally. So, for example, if you came and your family petitioned for you, you came as a green card holder, you came more than 7 years ago, you would meet that criteria. Or, let's say you came as a tourist or a student, and even if your visa expired, later on you became a green card holder. As long as the original entrance was at least 7 years ago and it was legal, you're going to meet that first criteria. The second criteria is that you have to have been a permanent resident or a green card holder for 5 years. So those are the two main criteria. People that commit, and you have to be not convicted of an aggravated felony. An aggravated felony is a particularly serious crime. It actually, one of the areas where we often have our fights or disputes with immigration when they're trying to deport people is whether or not someone is actually an aggravated felon. So these are the three major requirements for cancellation of removal. However, even if somebody meets these requirements, the judge has discretion as to whether or not they are going to grant a case. The other thing I think that's important is that when somebody's going through a case, immigration actually has the right to detain that person or put them in jail while the case is going on. And whether or not they are subject to a bond or can get bonded out is a topic for another video. So what does the court consider? What is the types of things do the court consider when they're considering whether or not to allow someone that's committed a crime to stay? One thing I think that's important to say is that you really want to present a good case. You want to present as much evidence as you can. The judges see people all the time that haven't committed crimes that are seeking to stay. So when they get someone that has committed a crime, their inclination may be not to let them stay. But sometimes they do let them stay. They look at things like this. How long have they been a resident? How long have they been a resident? If somebody's been here 20 or 30 years, then their ties are more to the United States than they are to the country to which they would have been deported. Sometimes we see cases, for example, where somebody came as an infant or they were 3 or 4 years old. They commit a crime at the age of 33 and the government's seeking to deport them. Obviously, they're more of a resident here than they are of their home country. However, judges often still deport these people. The judge will also look at what is their family ties in the United States. Do they have parents that are citizens, children that are citizens or permanent residents, etc.? Is there any particular hardship to the person or to their family members if they are deported from the United States? So that's another factor that the court considers. Another thing is, does a person have any ties to the community? Are they somebody that gives to charity? Are they coaching in the Little League team? Do they do other things that are of benefit to their community at large? Those are other things that are important. Do they run their own business? Do they employ people? All of those factors are factors that are considered by the judge in a cancellation of removal case. The main thing for anybody is to meet with a good attorney to try to come up with all of the equitable factors that would allow the person to stay. And what happens is that the judge looks at all of those equitable factors, all of the good things that the person has, and it's sort of a scale of justice where they look at the good versus the crime versus immigration violations, and then they make a decision based on discretion. Should I allow this person to stay or not? And that's a cancellation of removal case. You also can learn more about the procedures for that on De-Stressing Deportation Part 1. Even if you lose your cancellation of removal case, you do have the right to appeals of that case and so forth, as explained in that video. You can see all of our videos on our website, www.immigration-professor.com. Or if you have a specific question about a case or need representation, please call our office at 310-384-0200. We've appeared at immigration courts throughout the United States to present cancellation or removal cases, and we represent people in all immigration matters internationally. Thank you so much.